myself and 7 of my learned brothers, we have held that the judgment of the 7-judge bench in Synthetics and Chemicals Ltd versus State of UP is wrong on certain aspects and have overruled the judgment to the extent that is indicated in this judgment. Justice, my learned sister, Justice B.V. Nagaratna, in her separate opinion, disagrees with the opinion of the majority on specific aspects. The following were the issues which fell for our adjudication while deciding the correctness of the judgment in Synthetics. A, whether entry 52 of list 1 of the 7th schedule to the Constitution overrides entry 8 of list 2. B, whether the expression intoxicating liquors in entry 8 of list 2 of the 7th schedule to the Constitution includes alcohol other than potable alcohol. And C, whether a notified order under section 18G of the Industries and Development Regulation Act is necessary for Parliament to occupy the field under entry 33 of list 3 of the 7th schedule to the Constitution. The issues are answered as follows. The expression "that is to say" in entry 8 of list 2 cannot be interpreted to circumscribe the scope of the entry. The words that follow "that is to say" are illustrative and explanatory of the scope of the provision. The expression does not limit the scope of the entry. Thus, the scope of entry 8 of list 2 cannot be limited to the production, manufacture, possession, transport, purchase, and sale of intoxicating liquor. Entry 8 in itself indicates that the intent is to ensure that it is read as broadly as possible. The entry seeks to regulate everything from the stage of the raw materials to the consumption of intoxicating liquor. Entry 8 of list 2 includes both the industry and the product of intoxicating liquor. The power of Parliament in entry 52 of list 1 is defined by the phrase control. The entry does not read as industries declared by Parliament by law to be expedient in the public interest. The entry states industries the control of which by the Union is declared by Parliament by law to be expedient in the public interest. The law enacted by Parliament must not be an abstract declaration, but must specify the extent of control that is necessary to be taken in public interest. The state legislature will have the competence to legislate with respect to the field which is not the subject matter of control. The legislative competence of the state legislature is only denuded to the extent of the control by the Union declared by the law of Parliament to be expedient in the public interest. Irrespective of whether the term industry is interpreted in a narrow or a wide manner, a point that is vehemently contested by both sides, the industry of intoxicating liquors specified in entry 8 cannot be taken over by Parliament under entry 52 of list 1 for the following reasons. And we have given reasons. The general principle is that legislative lists must be interpreted widely. The question what the court must pose is whether the two entries would overlap when interpreted widely. Then B, the only limitation in entry 52 is that the control of the industry by the Union must be necessary for public interest. Parliament can legislate on any industry, provided it satisfies the condition prescribed in the entry. Thus, entry 52, when read independent of any other entry of list 1, list 2, or list 3, does not preclude the inclusion of industry of intoxicating liquor, provided that the Union is able to prove that its control is necessary in the public interest. Similarly, entry 8 of list 2, when read independently, also includes inter alia the production, manufacture of intoxicating liquor, which is included within the meaning of industry. Thus, entry 52 of list 1 and entry 8 of list 2 overlap on the aspect of industry of intoxicating liquor. Entry 8 of list 2 is not subject to entry 52 of list 1. Thus, the state legislature has the exclusive competence to enact a law on the field in entry 8. The court must distinguish between entries that are expressly subject to entries in the Union list and entries that are not. When one entry is not subject to the other, the court must harmonize the overlap of entries. The only way to reconcile the entries is either to exclude the industry of intoxicating liquor from entry 52 of list 1 or entry 8 of list 2. The court, while reconciling the provisions, must ensure that neither of the entries is rendered redundant. E. Entry 52 of list 1 is a general entry dealing with industry. Entry 8 of list 2 is a special entry dealing with one particular industry. The consequence of interpreting entry 52 to cover the industry of intoxicating liquor is twofold. First, it would amount to deleting the word production and manufacture in entry 8. And second, the state legislature also loses its exclusive competence to legislate upon the product of the industry, rendering entry 18.8 fully redundant. As a consequence, it is clear from the analysis of the judgments in F.N. Balsara and Southern Pharmaceuticals that the meaning of the phrase intoxicating liquor in entry 8 of list 2 has been expanded beyond the narrow definition of alcoholic beverages that produce an intoxicating effect upon consumption. liquids which may contain alcohol and which can possibly be used or misused as intoxicating liquor have been included within the meaning of the phrase. The interpretation based on legislative meaning elucidated in Gannon Dunkley, which narrows the interpretation of entries, thereby creating an exception to the rule of wide interpretation, should only be employed by courts when the twin tests highlighted above are fulfilled. The tests are A, the phrase should have acquired a well-recognized, definite, and precise meaning in law, and B, the legal import of the word must be practically unanimous. Additionally, we are of the view that the legislative meaning interpretation should be adopted only when the deviation from the popular meaning of the phrase is not too wide. The legislative meaning cannot be used to artificially narrow legislative entries. The definition of liquor in pre-constitutional statutes as liquids containing alcohol cannot be transposed to interpret the legislative entry. The phrase used in the legislative entry is intoxicating liquor. The definition of one part of the expression in statutes cannot be used to interpret expressions that are used to indicate a collective meaning, particularly when the common parlance definition starkly varies. The common parlance meaning of intoxicating liquor means liquor which causes intoxication, that is, which causes someone to lose control. Thus, the three-pronged test to identify if intoxicating liquor has acquired a legislative meaning has not been satisfied. And the Constitution uses three distinct expressions relating to alcohol: intoxicating liquor, alcoholic liquor for human consumption, and intoxicating drinks. The evolution of the entries in the legislative list indicates that it was a conscious decision to substitute alcoholic liquor with intoxicating liquor in the regulatory provision. It was also a conscious decision to use different phrases in the taxing entry and the regulatory entry. We do not think that it is necessary for us to lay down the contours of different phrases used in the Constitution. That is a decision for another day and in another case. However, it is still possible to draw some inferences from the different uses. The expression alcoholic liquor for human consumption and intoxicating drink are used in the context of consumption. However, the provision relating to intoxicating liquor is not limited to its consumption. It stretches to its production, manufacture, possession, transport, purchase, and sale of intoxicating liquors and beyond. The second difference is the use of the expression intoxicating instead of alcoholic as the adjective to liquor. The following inferences can be drawn from the above differences. A. Alcoholic liquor defines the scope of the provision based on the ingredient, that is alcohol. In contrast, intoxicating liquor defines the scope of the provision based on the effect, that is intoxication. Thus, even liquor which is colloquially or traditionally is not considered as alcoholic liquor may be covered by the phrase intoxicating liquor if it produces the effect of intoxication. B. Intoxicate means the ability of someone to lose control of their behavior. It could also mean poison. Thus, the purpose of substituting the adjective, which indicates the ingredient, alcohol, with the impact intoxication, seems to be to enhance the scope of the entry to cover liquor which has an impact on health. And C. The public interest purpose of the provision is evident from the accompanying word from the provision, which includes every stage from its production to consumption within the scope of the entry. The public interest purpose of the provision is also evident from the evolution of the entry. The relevant entry in the 1935 Act also regulated narcotic drugs and opium along with intoxicating liquor. References to narcotic drugs and opium were deleted to prevent its overlap with entries in the concurrent list. As highlighted in the previous section, a common thread that runs through alcohol, narcotic drugs, and opium is that they are products which can be noxiously used because they are also used as raw materials in the production of other products. It is clear from the above analysis that the meaning of the phrase intoxicating liquor cannot be restricted to potable alcoholic liquor, that is, alcohol that is sold as a beverage. Alcohol is an inherently noxious substance that is prone to misuse, affecting public health at large. The purpose of entry 8 is to cover alcohol that could be used noxiously to the detriment of public health. The entry covers all alcohol that could be prone to noxious use. It also covers variants of alcohol that are not used for the preparation of potable alcohol, but which could be misused to harm public health. This interpretation is in consonance with the mischief sought to be covered by the entry. Thus, while the entry covers ENA and rectified spirit, which are used in the preparation of potable alcohol, it also covers variants of alcohol, such as denatured alcohol, which though are not used in the preparation of potable alcohol, are prone to be misused. Item 26 of the first schedule to the IDRA must be read as excluding the industry of intoxicating liquor as interpreted in this judgment. The holding in Tikaramji is not relevant to the dispute for the following reasons. We have interpreted the phrase intoxicating liquor in entry 8 to include ENA since it could be noxiously used. And notwithstanding the above, if the ground for overruling the holding in Tikaramji is that manufacture or production cannot be disconnected from raw materials. It would also equally apply to the industry of intoxicating liquor covered by entry 8 of list 2. We have concluded that the words that is to say in entry 8 are illustrative. They are not exhaustive of the contents of the entry. Thus, entry 8 cannot be interpreted to exclude raw materials used for the production of intoxicating liquor merely because the entry does not expressly provide for them. On an application of the principle that entries ought to be interpreted widely, the raw materials for the production and manufacture of intoxicating liquor, as interpreted in this judgment, would be covered by entry 8. The issue of whether Section 18G of the IDRA covers the field of entry under entry 33 of list 3 does not arise for adjudication in view of the finding that denatured alcohol is covered by entry 8 of list 2. The reference is answered in the above terms. The registry is directed to obtain administrative instructions for placing the matters before the appropriate bench.